Closing arguments just finished in the Jennifer Crumbley trial this past Friday, and now the jury's going to come back on Monday to get their final jury instructions and begin deliberations to decide whether Jennifer Crumbley should be convicted of 4 counts of involuntary manslaughter. We're going to jump into that in just 1 minute, but before we jump into that, I just want to give you a little bit of information on this case before we actually get into the weeds, and that is that this situation, this murder happened in Michigan. This is my home state, and the Judge Matthews, who I've been in front of a number of times, the Oakland County Circuit Court, which I've been in many times, this is right in my backyard. So I'm very familiar with this judge. This judge, by all accounts, is very fair. Everybody has a very high opinion of this judge. So certainly the judge on this case was great. This actual shooting, which was horrific, was the 4 victims in this case was Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling. They were all murdered by Jennifer Crumbley's son, which we're not going to mention in this video. He is just going to be referred to as the shooter. So Jennifer Crumbley's son, the shooter, in cold blood, murdered these 4 innocent, pure souls, and now he was already sentenced to prison for the rest of his life. And now they're charging the parents, Jennifer and James, with involuntary manslaughter. And another thing that you should know about this case is that there's actually a civil case that was filed also against the school for the school's negligence, or perhaps gross negligence in this case. And so this is a criminal case for criminal culpability, but then there's also a civil case that these families are filing against the school for money damages for the loss of their children. So that case is actually being handled by an attorney named Venn Johnson from Johnson Law. Venn Johnson is one of the best trial attorneys in the entire country. So if that case actually goes to trial, it will be very interesting to watch that trial play out, because he really is one of the top trial attorneys in the entire country. So that's just another point, something that also may be coming up in the future. So, but let's jump into this case, and we'll talk about the elements, the law, and some of my feelings about the closing arguments, and some of my opinions on the case in general. So let's just get you caught up on some of the facts that came out during evidence. Of course, I'm not going to cover everything that ever came out, so if I do miss an important fact that may happen, but I'm just going to give you the general sense of what's going on here between the 2 different sides, and then we'll jump into the law and what possibly the jury can be thinking about when they are deliberating. So let's start with the text messages in March and April. There's some text messages in March and April where Jennifer's son is telling her that he feels that the house is haunted. He feels that the house is haunted and doors are closing, and he just feels like things are dropping. He just feels like the house is just a haunted house. And wouldn't that suggest that he's got some mental issues if he thinks his house is haunted? But the way that she explains this away, Jennifer explains this away, is that, well, there was always it was an ongoing joke that she had, and she and her husband James had with the shooter, with the son. They had this joke that the house is haunted, and they got this house really as an auction, and they got it for a good deal, and they're rehabbing the house. So it's one of these old houses anyway, and it kind of fits into the whole narrative that it's a haunted house. But she said that was just an ongoing running joke, and there's nothing really serious about that. She never imagined that there was any mental health problems with her son throughout this entire period of time. Now, at one point, her son was looking up ammunition in school. He was looking it up in school, and she got a voicemail about that from the school. And the way that she describes it was a very nonchalant voicemail, just letting them know, oh, your son was looking up ammunition. He's not allowed to do that. And, just we thought you should be aware of it, but not like you have to come and pick him up and get him counseling or anything like that. She even said in the voice message, you don't even have to call me back. So, but there was that time when he was looking up ammunition, and something that she mentions to her son afterwards when they're texting this, apparently, she texts him, ammunition? Like, what in the world are you doing? And then she says something about don't get caught next time. So what does that mean? Don't get caught next time? Doesn't that look terrible? Doesn't that look like she's just encouraging him and just telling him not to get caught? I mean, that looks terrible as a parent, right? But she explains this away as that they understood in the family. And this is also just something that we could be thinking, is that it's very hard to understand just from some few text messages, some isolated text messages, what the entire context is. That is true. That's a good point, and that's the point that the defense brought out about all of this. But the way that she explained this away is that she would tell her son that whenever she was younger, she would always be doing getting into trouble with some other friends of hers. And for some reason, she was always the one who got caught. So they're all doing something wrong, and she would always be the one who got caught. So she would always kind of make a joke, don't get caught, when you're the one doing something wrong. So that was just what she meant. Of course, she didn't mean that he should do whatever he wants as long as he does not get caught. Now, there are some text messages also from Jennifer to some of her friends, which also are telling her friends, that her son, the shooter, is actually messed up. He's weird, and he's an oops baby, meaning she never really meant to have him in the first place, and that he's just messed up, and things like that. So there are some text messages between her and her friends saying how her son is messed up. Now, the defense tried to explain this away as saying, this is a teenager. Anybody who has a teenager can be talking to their friends about, my gosh, my teenagers are driving me crazy. They must be crazy. They must be out of their minds. So that's just a regular way that sometimes you talk about your teenage children. Now, there's also some text messages that the son, the shooter, has with his friend. He has one close friend. Now, Jennifer says that he actually had other friends also in school, but he had one really close friend who she calls a second child, was always over at the house. They would go bowling together. They were part of bowling leagues together. And he had this one really, really close friend. And in text messages between her son and this friend, it shows from the text messages that he was saying about how messed up he is, and that his parents are ignoring his problems, and that he hears these voices in his head telling him to do certain things, and the voices won't stop, and his father just jokes with him and says, suck it up, and the mother is just laughing at him and not taking any of his concerns seriously. Now, the mother, of course, denies it. The mother says on the stand that he never came to her with any request for help. And these are just text messages that he has with his son, and that she never saw those text messages. And then the question becomes, where should a parent be monitoring their children's text messages with their friends, especially a teenager? Now imagine trying to monitor your teenager's phone. It's going to be very difficult to every single night get the phone from your teenager and say, I need to go through all your text messages and make sure they're okay. And the teenager can also be deleting text messages that you cannot always see that. So, but this was also an issue of, should she have seen the text messages? Should she have been monitoring her son's text messages when this is all going on? And then she would have seen what he's saying to his good and close friend. Now, another thing that came out was that Jennifer likes to spend a lot of time with her horses. She had a barn, and she would spend a lot of time. Horses need a lot of time, and she was there, and she'd spend a lot of money on them as well. And part of the suggestion here by the prosecution was that she cares more about her horses than she actually cares about her own son. She has one son. Give him some more attention. And the prosecution and the defense brought out that no, she would spend plenty of time with them. They would play board games together. They would eat together. They would go out together. They'd have fun together. So it wasn't just like she was completely ignoring him, but she did have a hobby. So what's the problem? The defense part of the argument was, what's the problem with a parent having a hobby? We all need to relax in certain ways, and this is the way that she relaxed. She relaxed with her horses. It doesn't mean that she was ignoring him or not. And also there are some testimony that came out that her son would never come with her to the barn, that he didn't want to go, and she would say, yeah, he didn't want to go. It's not like I'm ignoring him and forcing him to stay at home by himself. He just didn't want to go. And there's some other parties that she went to, like a Halloween party that he didn't go to. He stayed at home. And why was that? Well, she explained because the party was for little kids, and he's a teenager. He doesn't want to be hanging around these little kids. So you've got this going on. Now, the night, or not the night before, but sometime before the shooting, pretty close in relation to the shooting, the son, the shooter's pet, dies. So his pet, who he's very close with, obviously someone doesn't have that many friends, very close with his pet, and the pet dies. So that obviously is a big blow to him. And then also this friend moves away. So his one very, very close friend moves away, literally just a few days before the shooting. And you can imagine that can really crush a kid, especially this is his one good friend. And then the night before, there was a fight. There was a fight the night before, and that was because Jennifer approached him and was asking about his missing assignments. He wouldn't do his homework and wouldn't do his assignments, and she would always get notices about it. So they had this constant running arguments about him not doing his assignments, and she would always be arguing with him that he has to do his assignments, and therefore she would impose certain consequences. And some of those consequences included taking away his phone, as well as taking away his rights, his privileges to go to the shooting range. Now, the shooting range in this situation was the following. There was a few guns in the house, and this was a family that was okay with having guns. Now, she testified that she didn't really like the guns that much, and it was really more her husband enjoyed guns, and her husband and the son enjoyed guns, but she really didn't have much to do with it. She was okay with it, but she didn't really care that much about the guns. She wasn't such a gun enthusiast. And they already had 2 guns in the house, and then they went and they purchased a 9mm gun, which was the murder weapon in this case. They purchased a 9mm gun, and they called it, and she even said this on social media, she called it his present, meaning her son's present, and his gun. And a number of times she refers to it as his gun. And that's something that the prosecution brings out and makes an argument about, that look, what do you mean his gun? If you're buying the gun for yourselves and then he'll just use it and borrow it, okay, that's one thing. But here you're saying that you're buying him a gun and you're bragging on social media that this is his gun? So, what in the world is going on? But to rebut that, the defense does argue that this was a town, and you have to understand the mentality in this area where these people were living, and certainly in this school. It was very common for families to have guns, and for them to go to shooting ranges, and for them to go hunting. And in fact, she says that a lot of the girls, when they were taking certain pictures, they would take pictures of themselves with their guns. So it was a very normal thing that the school had to remind them not to bring any guns to school or things like that, because they just went hunting, and they would have these days that people would be running around with guns. So therefore they would tell everybody, just remember to keep all your guns at home today. So this was a town that they were okay, and it was very normal for everyone to have guns. So even though to some people it may sound like, well, sounds like guns are out of control over there, but this was normal in their society for people and families to have guns, for them to go to shooting ranges, and this was normal. So that's kind of how the defense is trying to portray this, that this wasn't a situation where they're just buying him a gun and saying have fun. This was, okay, this will be your gun when we go to the shooting range. I know you like to have this type of gun. You were looking at a 9mm. Okay, fine, that's great. But of course, we're only going to use it at the shooting range. And that's what the argument from the defense was, that it wasn't his gun. Of course, it's not his gun, but this will be like, he was always wanting to shoot this type of gun, so that's why we got this type of gun as well. So that has to do with his gun. Now, there's some points brought out that she deleted a number of her text messages about certain things, certain incriminating things, and the defense argued that, well, she just would be a chronic deleter of text messages, and she even deleted text messages that were exculpatory. So, she was deleting all types of text messages, not just the ones that incriminate her, but also the ones that make her look better. So, the fact that she is a chronic deleter of text messages does not mean anything significant. Now, they also, when the news came out that they were going to be charged, or perhaps they're going to be charged, they ran away. They were going to different hotels, and they were trying to lay low. And the suggestion here is that they're trying to run away. And this shows consciousness of guilt, right? This shows that obviously you understand that you did something wrong. Otherwise, why are you trying to run away? Now, the defense tries to spin this in a way that, no, they're not trying to run away. They're scared for their life. After this came out, they were getting death threats themselves. And they were nervous to just turn themselves in in a regular fashion. They wanted to do it with a lawyer, and perhaps that would provide them more protection. So they weren't just trying to run away. They were trying to just lay low for a little bit, try to drop off the grid a little bit so that they won't be bothered by people and they won't have safety concerns. So that was the point. But on the other hand, you do have some text messages from her to some of her friends saying, oh, shoot, we're going to get caught, or I think we're getting caught, or we're screwed, so something like that, where it sounds like she's actually trying to hide and run away. But again, the argument back would be just, no, we're just trying to hide until the time we're going to turn ourselves in, but we're not trying to actually run away from ever getting arrested. So that's that. She also made a withdrawal of a lot of cash. Why is she running around? Why is she withdrawing basically all of her money from all of the cash that she has in her bank account? Why is she doing that? And there, again, the suggestion was, the defense's argument there was that, no, she's just withdrawing cash because she can't use her credit card. If they're going to see her name and she's going to pull out ID, everyone's going to know who she is, and she wants to lay low. And that's the whole point here, is to lay low and to just use cash. That's the smartest way to do it. Also, her father said that that they're going to freeze her account, so therefore if she needs money to live, she should take out some money. And that's why she just listened to her father by doing that. So that was that. Now, coming up to the actual day of the murder. So the night before, they're in this tremendous fight, and again, two different stories about what happened that night. The prosecution says that they were in this fight because he wasn't doing these assignments, and the night before, again, this is the night before the shooting, that he was, that she said, Jennifer said, we're going to take away your phone again, and you're not going to be able to go to the shooting range. And these were his two trigger points, because she knew that this really bothered him. These are his, to take away the technology from your teenager is not going to be pleasant. The teenager is not going to like that. And especially his one happy thing that he likes to go to the shooting range, you're taking that away, that's also going to be a trigger for him. So the prosecution claims that they were in such a fight that they locked him out of their house. And she said, what are you talking about? We never locked him out of our house. He was just mad, and because he was so mad, he walked out of the house himself to get some air, to get some space. And that's what he was doing. So they have these different conflicting understandings of that situation. And then they also said that, well, you didn't really take away his phone because he had some sort of video that he took that night, and that night, the night before, saying things about what he's going to do the next day, about shooting up the school. And how could he have had his phone if you took away his phone? So that video actually didn't come into evidence, but there's some suggestions that the video was actually made, and therefore that was some of the arguments that were made there. So that's what happened the night before. The next day, so the parents get an emergency call to the school. And you don't always just call parents to the school for emergency meetings just because your son is acting up. It has to be very serious. So right away, they should have these alarm bells. And she actually texted her husband, emergency. And the husband said, like, oh my gosh. Oh, I think they said WTF. And they both went to the school together. They had this emergency meeting. And at this meeting, they show the picture that her son drew. The picture that her son drew of this exact 9mm, which was his gun, and a picture of a dead person on the floor with blood coming out of them, and with some other comments that he made on that math sheet. It was a math sheet, and that he drew all these pictures. He was a little bit of an artist, and they actually had some testimony showing that he actually drew almost to the exact same thing as his 9mm gun. Now, here's where it gets a little interesting, because they come to the school, and the prosecution makes a big point that she doesn't go over and hug her son, or even acknowledge her son. Now, on the one hand, yeah, it looks like, oh, you're so mean that you don't go over and hug your son. But on the other hand, you just got called to school because your son is acting up. Are you supposed to show him all this love now and shower him with all this love? Of course you're going to be upset. And you should probably want to show your son that you're upset, that you just had to take off from what you're doing in the middle of the day to go down to school. Okay, but they still made a point about that. And so they go into this meeting, and in the meeting they show them the picture of the gun. And what's interesting also is that they were actually carrying his backpack, and in the backpack was the gun. And they were making a comment about how this is the school, how heavy this backpack is. And they never decided to search the backpack. So, this opens up, again, the school for a little bit more. Well, you should pay more attention about what's going on there. But that's what happened. And the school tells the parents, essentially, it's okay. As long as you get him counseling within 48 hours, he can stay in school. And we just wanted to let you know about this. This is serious stuff. And you're free to go, essentially. And we're not going to force him to go home. And here was the question. Can a school actually tell a child to go home and force a child to go home? So here the prosecution was saying, well, the school says that they're not able to do that. They're not able to force the kid to go home. But on the other hand, the defense attorney says, what are you talking about? I get phone calls all the time that I can't send my kids to school, and if they have a fever, I'm not going to send them there for another 24 hours. I get all these reminders, and that my kid's not allowed to go to school. So what do you mean you're not allowed to send your kid home? Of course you're allowed to send your kid home. Send somebody's kid home. So as far as the Crumbleys are concerned, Jennifer and James, the school said, okay, you can go. So here is where a big part of the argument is going to lie, because the prosecution is saying, well, if you would have known everything that Jennifer knew about her son, then of course you would not just walk out of that door. You would be much more nervous about something actually happening. If you knew about this whole 9mm, you knew that you bought him this gun, and you knew that actually, another part of this is that the last time they went to the range, Jennifer actually went with her son. They went to the range together, and Jennifer represents that outing as a time that she was so blown off her chair because her son actually asked to spend time with her. And when you have a teenage son, and you're the mother, and usually the teenage son wants to have nothing to do with you, and he asks you to spend some time together, even if that's a shooting range, you're going to do it. And that's what they did. So they went to the shooting range together that time, and she ended up leaving the gun in her car, because she said that really she had nothing to do with the gun. It was all James, her husband's, responsibility to put away the gun and secure it. So she just left the gun in the car, not wanting to have anything to do with it, and just going to wait for James. And she said that she texted James, "Can you please take care of that gun?" But for all intents and purposes, that gun remained in the car, and that's perhaps how the son got to the gun. Anyway, so if you would have known all of this, again, so now we're back at the meeting, and the prosecution is saying, if you would have known all these signs, all these triggers, all these mental health warnings that you're getting about your son, and then you see this picture, you wouldn't just walk out of that school building. You would make sure you take your son, you would search his backpack, you would do something to make sure that your son's not about to do something terrible. So that's also a big part of it. Now, the argument back is that you've got a mental health professional sitting right there, the social worker at school, and that mental health professional is telling you that everything's fine. You don't have to be worried. So yeah, maybe he didn't have all the information. Okay, these are the arguments back and forth. But the question is that going to amount to gross negligence on the part of Jennifer and James? Eventually, James is charged also. His trial is going to happen in a few months or a few weeks, something like that. So that's really where a lot of this comes down to, was Jennifer grossly negligent. And this is where we get to the involuntary manslaughter. Let's explain what involuntary manslaughter is. So involuntary manslaughter, by its definition, means that you did not intend on anybody dying. You did not intend on shooting anybody. You did not intend on anybody dying in any way. But you were grossly negligent in a certain way, and because you were grossly negligent, that is what led to this person losing their life. So for example, let's say you have a person who's in a fight, and he has no intention of shooting the person. They just have an argument. But to make the point, he takes out his gun to wail it around to show, I'm serious about this. But he never has any intention of shooting anybody. And he takes out the gun, and he starts wailing it around, and it goes off by accident, and it shoots the person. That's involuntary manslaughter. You never intended for the person to die, but you acted in a grossly negligent manner, and therefore the person ended up dead. So this is how the prosecution presents the two theories of this case. Take a look.
One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, defendant acted in a grossly negligent manner.
So the first thing that I have to say about this is I don't understand what that first theory is. That first theory is grossly negligent in the performance of a lawful act. So again, you're grossly negligent when you are doing a lawful act. And I just don't understand what that means. How can you do a lawful act if you're acting in gross negligence? If you are acting in gross negligence, that is against the law. So I'm not really understanding how that first theory is actually applicable. So maybe some of you can help me in the comments understand that first theory. Now the second theory I get a little bit better. The second theory is that you were grossly negligent in failing to perform a legal duty. Now what's the legal duty here? Let's understand this. The legal duty here is that a parent, under Michigan law, a parent has a legal duty to exercise reasonable care to control their minor child from harming others. So you have to make sure, you have to act in reasonable care, you have to act reasonably, that your kid is not going to hurt someone. So if you see your kid walking out of the house with a gun, and he's mad, and he's talking about how he hates his friend, then you have a duty as a parent to try to get your kid not to do that, right? Also, you're not allowed to just leave guns out in the open when your kids can come and get them and use them. That's also not acting with reasonable care. So that is the duty that Jennifer had. Even though her son is 15 years old, doesn't matter if he's 5, 10, 15, or even 17 and a half. As long as he's a minor child, you have a duty as a parent to exercise reasonable care to control them, that they don't hurt somebody else. And this is if you are grossly negligent. So there's one thing which is negligence, but now you have to be grossly negligent in failing to perform that duty of preventing your child from hurting somebody. So what does that mean? So that's broken down into a few different things. Number one is that you have a legal duty to the victim. Number two is that you knew of the facts that gave rise to the duty. Number three is you willfully neglected or refused to perform that duty, and that neglect was grossly negligent to human life. It was grossly negligent to human life, that neglect to perform that duty. The fact that you didn't perform that duty, that shows that you're grossly negligent to human life. So what's gross negligence? That's an important part also. Gross negligence is willfully disregarding the result that might follow from an act or failure to act. You're knowingly and willfully ignoring the result that could happen. And this is also broken down into three different things. Number one, you knew there was a situation that required you to take ordinary care to avoid injuring another. So you knew of the situation. So in this case, Jennifer knew of the situation of her son's mental health problems and his depression and his pictures that he's going to go shoot up the school. Number two, you could have avoided injury by using ordinary care. And number three, you failed to use that ordinary care. And it was apparent that the result was likely to be serious injury. So it was apparent that it was likely that by you failing to use that ordinary care, serious injury was likely to occur. So here, by allowing him access to the gun, let's say, or being negligent with your storing the gun, it's to a reasonable person, it's apparent that by doing that and understanding your son's situation here, his mental health problems, his depression, and everything that just went on, that he lost his best friend and he lost his pet and everything like that, and his drawing of his pictures, that you knew that your serious injury was likely to occur. So that's gross negligence in this case. And this is what the prosecution has to prove. Now, a few things that I want to mention that they did well in their closing arguments, the prosecution. Number one, they embraced their burden. And I always talk about this. I always talk about how it's important to embrace the burden. And when you're a prosecutor, you know, especially in a criminal case, that the defense is going to get up and going to talk about reasonable doubt and how hard it is and how such an incredibly high burden it is to prove reasonable doubt. And therefore, as a prosecution, you can't ignore it. You have to say, we understand what the burden here in this case is, and we're completely embracing that. That's no problem for us because you're going to see so clearly. You're not going to have any doubt in your mind that Jennifer, in this case, is guilty of 4 counts of involuntary manslaughter. And that's something that the prosecution did in this case, and that was a good job that they did that. She also makes the point of that she drew him a picture. She drew him a picture of what she was going to do, what he was going to do. That picture, that morning, was exactly what he was going to do, and that's what he did. So if you're the parent, how do you not stop that? That's gross negligence. Now, the defense, I thought, in this case, did a good job in arguing their closing argument. I think she did a great job. And some of the things I think that could have been maybe just a little bit more emphasized is the following. Number one, ladies and gentlemen, this trial is not about whether Jennifer is a good mother. She may be a terrible mother. That doesn't make her a murderer. That doesn't make her guilty of involuntary manslaughter. It just doesn't. She may be a bad mother. There's a lot of bad mothers out there. There's a lot of them. We're not going to throw all of them away in prison. Maybe she was a bad mother. And I think that this was a point where the defense tried to make the argument that she's a great mother and that she really cared and that she wishes, the defense attorney was saying that she wishes that she was like as good of a mother as her client. I don't think that that's the best way to go about this. I think it's okay to make some arguments perhaps that we're taking this a little too far, but let's just give them that. Make a concession here. Make a concession and say, you know what, maybe she's not the best mother in the world. And maybe she does have some problems. Maybe she should go to some parenting classes. Does that make her a murderer? Does that make her guilty of involuntary manslaughter? No. So the fact that she's a bad mother, she's not on trial for that. And she's also not on trial. You know what else she's not on trial for? Her moral choices, because there was some evidence that came out that she was involved in this affair, and how that came out was also interesting how that came out. But it came out that she was involved in an affair with one of her friends, and you're right, that was a terrible moral choice that she made. But she's not on trial for her moral choices. That has nothing to do with the involuntary manslaughter. So this case is not about that. This case is not about how messy her house is, because there's some big points about this by the prosecution, that her house is so messy. And look what her son was living in. Well, her son's 15 years old. Maybe he should clean up the room himself. Okay, well maybe she should have been more involved in that. Okay, fine. Maybe she should have been. Does that make her a murderer? Does that make her guilty of involuntary manslaughter? So the case is not about that. And also, another thing, which was kind of brought up a little bit, but I think it could have been said a little bit stronger. Ladies and gentlemen, you have to understand, and this is just me stepping into the defense attorney's shoes. Ladies and gentlemen, you have to understand that you are right now making history. We are all making history, not just in the city that we're living, not just in the county that we're living, not just in the state that we're living. We are making history in the entire country of the United States, because there has never been a case where the parents are being charged with involuntary manslaughter for a murder that their minor child did. This is the first time in history. There may be a reason for that. This is overreaching. This is overreaching by the prosecution. None of this is going to make anybody feel better. And again, of course, you have to acknowledge that there are victims here, and you have to acknowledge that the victims' families are here, and you say, and the most justice that could have been done was done. The person who committed this horrible, heinous crime is going to die in prison. He was sentenced to death in prison. So he's going to die in prison. So now what do you want to do? You want to lock up everybody else that had anything to do with this? It's overreaching. It's not going to make anybody feel better. It's not going to help in the healing process. This is just overreaching. And she did make this point. I think it just could have been done maybe a little bit stronger. Now, in terms of, you could have also used, as a prosecution, you could have used other examples of involuntary manslaughter to show that this is just too removed. So involuntary manslaughter, so like for the example that we gave, if somebody pulls out a gun and starts waving it around, he's the one that shot the person. He is the one that shot that person. He should have never been waving around a gun. Let's take another one. Let's say texting while you're driving. You're driving 100 miles down the highway, and you're in the middle of texting, and then you slam into someone and you kill them. You are the one that did it. You're the one that was texting. You're the one that made the decision to go 100 miles per hour, and you're the one that went and smashed into somebody and killed them. That's you. Here, the parents weren't even involved with the murder. This is just too removed. So that's another argument that could have been made by showing some other examples of involuntary manslaughter, that to show how this case is not as simple as a regular involuntary manslaughter case. Also, another point, consciousness of guilt. So the prosecution wants to say, well, they were hiding. Jennifer ran away. She knew that the police were onto her, and she was hiding because she had all this consciousness of guilt. She knew that she did something wrong. Well, let me tell you something. This has never been a case. This has never been a situation. This has never been where a parent is charged with the murder of the child. How can they have consciousness of guilt of that fact? Maybe they had some guilt of maybe not being the greatest parent. So maybe that's why they were running away. You're right. So you have consciousness of guilt that they're not a great parent. Does that mean they have consciousness of guilt of involuntary manslaughter, the first time it's ever being charged in history to the parents of a child? Not necessarily. That argument wasn't made. But a lot of these similar arguments were made by the defense, and I thought that she did a good job. And of course, something else which I thought was just another cute way that she could have made an argument. And this is just something where you foresee what the prosecution may do, because the prosecution's rebuttal. And of course, we get to look at this, after we see everything, and then say, "Oh, she could have done this." So obviously, obviously, I understand it's harder when you're actually there. But the prosecution's last few slides were showing the pictures of the victims, and of course, that's how you slam it home, right? You say these four people, these four innocent children, were murdered in cold blood, and you're trying to invoke the sympathy of the jury. And something else that the defense could have done very strong, which she didn't really do, which I think she could have done a little bit more. The jury instructions specifically say you can't base your verdict on sympathy. Sympathy can play no role in your verdict. And she did make a point of the only reason why the prosecution showed you some of those videos of the shooting, those horrific, terrible videos of the shooting, what's the point of that? What does that have to do with the way that Jennifer raised her child, or whether Jennifer was ignoring certain mental health issues? What does it have to do with it? Why did she have to show you that? The only conceivable reason that she showed you that was because to invoke sympathy. So she's trying to go against these jury instructions. The jury instruction says specifically not to use sympathy. Now, she did mention this, but I think it could have been stronger if you show the jury instruction or talk about the jury instruction and say, the judge is going to tell you you can't use sympathy. And here she is trying to invoke your sympathy. And here's just another cuter way that you could have foresaw her potential, what the prosecution was going to rebut. Because the prosecution, again, showed some of the pictures at the end of her rebuttal. And as the defense, you could have got up there and you could have said, and you know something? I bet that, of course, the prosecution is going to get one last word with you and I'm going to have to sit down. And I get no chance to rebut her rebuttal, right? I bet you that she's going to now try to invoke some more sympathy by showing you some of those pictures. I bet you that she's going to do that. I hope she doesn't. I hope she doesn't, because that's not what this case is about. But I sense that she may throw up some more pictures of these victims just to invoke some sympathy, because it has nothing to do with the case. And then the prosecution has to make a split-second decision about whether to actually show those slides now. So that's just something that, okay, it's easier to say as we're sitting back down here after we've seen that that's what she did, but it's also something that you could have, foresaw that that's probably how she's going to end it. And then at least you know that she's not going to, either she's going to show those pictures and then she's going to look like a total idiot because you just said why she's doing that, or she's going to cut them out and that's what you want anyway. So that's also something that she could have done. So all in all, I think that both sides did a very good job in this case. I think that the defense's closing argument was very strong. And look, I mean, it's a novel case, and nobody knows what a jury is going to do. Ultimately, nobody knows what a jury is going to do. But I think that there's a strong case to be made that Jennifer is not guilty of involuntary manslaughter. And there's nothing to do with that. I don't want justice for the victims. And of course I want justice for the victims. And my heart goes out to the family and everything like that. But when you're just looking at this through the lens of the law, objectively, and applying the specific facts that happened in this case, and a lot of people made some mistakes. They did. Everybody made some mistakes. The school made certainly mistakes. She made mistakes, Jennifer. Maybe she should have been more on top of it. But to say that she was grossly negligent and she couldn't care less about the serious injury that's going to arise because of her inactions, it's a stretch. It's really a stretch. Now, the jury could come back and find that. But I certainly think that there's a place in the jury for the jury to come back and say, we just don't think that it rises to involuntary manslaughter. So we will see what the jury does. They're going to start deliberations tomorrow on Monday. And hopefully this was helpful. And if you haven't yet, please subscribe, like, and we will see you next time.